Hello, welcome. I'm immigration attorney Pace Rawlins, abogado su alcance, and I'm so excited to talk about this topic, the newly announced Family Unity Parole-In-Place. We're going to talk about what we know and what we don't know. Remember that this is general information that should not be taken as legal advice, as you should seek a consultation with an immigration attorney. Let's get started. It's been reported that approximately 500,000 undocumented spouses of U.S. citizens and 50,000 of their stepchildren may be eligible for parole in place. To give you a little bit of perspective and in comparison to that, right now we have approximately 800,000 or more DACA recipients. Yes, it is possible to get a work authorization document or work permission once you have a approval of this parole document. Once you have that, then hopefully you can get this, which is your work permission, most likely underneath the C11 category. And when you apply for parole in place, you cannot concurrently file your work permission. You have to first wait for approval according to the questions and answers on USCIS. You also may be able to get a work permission under the C9 category if you file your I-45 adjustment application before. So whether you file for one or the other work permissions or both, you'll need to speak to an immigration attorney about that. Yes, it is possible to get your green card. That's the whole purpose for this parole in place program. But just because you get a parole in place approved doesn't mean you're going to be eligible to adjust your status and file for a green card. There are other things that are very important to determine that, whether you're admissible or inadmissible. Crimes, frauds, misrepresentations, deportations, smuggling in family members or non-family members into the country. Those type of things and many others could affect your ability to get a green card. So you should always seek a consultation with an immigration attorney. There are 3 basic requirements, and then there are also certain factors that could disqualify you. The first requirement is you have to be present inside the United States, and it looks to your last entry. Did you enter the country illegally or without inspection? Or did you enter the country with a visa or parole? Because if you enter the country with a visa, whether that's a B1, B2 tourist visa, or a F student visa, or any work visas, then you would not be eligible. Also, if you were already paroled, you would not be eligible. The second requirement is as of the date of June 17th, 2024, and I love the date, June 17th. That is actually the date I was married. You need to prove 10 years of physical presence inside the United States. So that means if looking back to June 17th, 2014, you should have been here in the United States living or had entered. So how are you going to be able to show that? Well, with lots of different documentation. That's why an immigration attorney would be really good to tell you what kind of documents. I'll talk to you a little bit about that. Other cases that are very similar that use this 10-year requirement are, one of them is a court case called cancellation removal for non-lawful permanent residence. It's a defense in court where you have to prove 10 years of physical requirements. But also in deferred action for childhood arrival DACA cases, we also had to prove presence from certain dates as well. And that was very document intensive. Typically, we would like to show proof of presence from the earlier date. The more you have around that June 17th, 2014 date, the better off you'll be. If you have stuff before that, really good. But also you'll want to show the continual presence up until that date, which means you don't need to show documentation every single day, but if you can show every month, that's going to be good. If you don't have everything every month, you're going to want to fill in those gaps, usually with affidavits. That has been my experience with cases very similar. But remember, parole in place, we're still waiting for more information on what documentation they want. So stay tuned. Requirement number 3 is you have to show that you were married to a U.S. citizen as of the date June 17, 2024 or before. So that means if you get married later after that date to a U.S. citizen, unfortunately, you would not be eligible. Now, here's a question that I've been receiving lately. from many people, clients including, what if you're already married and you're married of that date to a permanent resident and then they later become a naturalized U.S. citizen? That's a good question. Based on reading that, it sounds like they had to have been a U.S. citizen as of that magic day of June 17, 2024. However, we still don't know. There's other laws that once you naturalize, you can date that back, but we still don't know. There's a lot of things we don't know, so stay tuned for that. The other thing is, let's say that you live in a state that allows for common law marriage. So this is really important because immigration laws follow the law of the state when it deals with marriage. I am licensed in several states, including Arizona and Texas, and I practice and have a lot of clients in those states. In Arizona, it's a non-common law state, which means the marriage date is when you get married in the court or in the church. That is the date of the marriage. However, in Texas, they allow for common law marriage, which means that there are a lot of couples who live together as if they're married, and common law is allowed. So how do you prove that that's a valid marriage? Well, there's something in the state of Texas called an informal declaration of marriage, and there's possibly in this other states. So I know there's other states that practice it as well. And under that, if you can get this informal declaration showing that as of a date past, you have lived together in the same roof, you intended to be married, and you held yourself out as being married, you can get that date back on that informal declaration, which means you might be eligible if your common law spouse is a U.S. citizen. This is also very important in some instances with stepchildren, because immigration law says that stepchildren had to have been the stepchild before the age of 18. That means the step parent and the biological parent had to have been married. So this common law states and non-common law states legal analysis comes into factor of that. So make sure to seek a legal consultation with an immigration attorney on this issue. Other factors to consider when applying for Parole-In-Place is if you have any arrests or convictions, because any crimes could disqualify you for this benefit. So what are disqualifying crimes? Today we still don't know. We're waiting for that information. But looking back at other applications, for instance, the one that I like to look to is DACA. DACA was really different because there were certain crimes where it typically would not make you inadmissible for a green card, but it would make you ineligible and disqualify you for DACA. For instance, one instance of many is a DUI, driving under the influence. That typically did not make you inadmissible for a green card, but USCIS considered a DUI a significant misdemeanor to disqualify you for DACA. I don't know if that's going to happen here at Parole-In-Place. It might. And there might be other crimes too that surprise us. Without a doubt, if you have any convictions or any arrests, you'll need to see an immigration attorney, do a background check and analysis. And also, if you have any violations with immigration, if you ever were picked up at the border, if you ever were deported, if you committed a fraud and misrepresentation in any immigration application or visa, if you falsely claim to be a U.S. citizen, if you smuggled a person into the United States, these are a few of the things that could also disqualify you in discretion. One of the questions that we have is the permanent bar for entering the country and staying more than a year unlawfully, leaving and then re-entering illegally can create a permanent bar. And I have lots of clients and potential clients who are asking me whether this will disqualify them for Parole-In-Place. We still don't know. My gut tells me that you still might be able to get it, but if that could be a factor for an official USCIS to disqualify you. Get a consultation if you have any concerns about any disqualifying crimes or immigration civil violations. As of the time of this recording, we still do not know the date you'll be able to file your applications for this new Family Unity Advanced Parole, but we have been told that it'll be late summer. Also, remember that if you do file early, USCIS will reject your application. So seek a consultation now. Do what you need to do to get prepared. Feel free to reach out to me through my messenger or contact me by calling 602-777-7223. That's 602-777-PACE. I'm attorney Pace Rawlins, abogado a tu alcance.